Welcome to the Estates Made Simple podcast with Jenna Carvello and Gordon Vanderleek. We are on a mission to simplify the world of estate administration, helping executors gain the knowledge required to manage an estate. Please note, the following is for informational purposes only and is not to be considered legal, tax, or financial advice. We recommend you seek individualized advice for your unique situation with qualified professionals.
Welcome to another podcast episode of Estates Made Simple. The purpose of this podcast and where it started with would be our kind of mutual passion about talking to people about estate administration issues. Jenna, if we think back to when we first germinated the idea of starting this podcast, I think that was a bit of the theme, and it's been fun over the many episodes to have conversations, and we're get to do that again. So welcome to the podcast. And we're looking to talk about the different powers or different provisions that are in a will. I liked how you phrased this on the outline, which is, why does a will have to be so long? And it's interesting. I have to remind clients when we're looking at the wills, I go, it's the first number of pages that are drafted uniquely to the client. And then there's a whole bunch of these template clauses that we can call them the administrative provisions. And what the heck is all this stuff? So I do get it that those pages seem to outnumber the pages that are particular to the family and the substantive part of who's the executor, how do things get distributed, what are those sort of various provisions. So I thought it was a great topic to maybe talk a little bit about why the heck do lawyers put all these provisions in there, looking at it through the lens of estate administration. Like, how is this helpful for the personal representative of the estate? Have you had that feedback as well, like in your days working at the trust company or even talking to clients these days?
Yes, absolutely. That's one common question. And I think it does bring up a lot of confusion because the client is reading the will for the first time. First of all, they may not know how to read a will. So as you put it, the first few pages are really the most important. And then the rest is just additional powers. But I really do think those additional powers are useful because you never know what assets are going to be held in the estate or what objections have to be overcome by the executor. So to have those provisions in there, if needed, can be really beneficial and reduce costs in the long run.
Yeah, I have in the past explained it, so maybe it's useful, again, as we get into the topic, is to think of it as tools in the toolbox. I know by analogy, years ago, we went through a big renovation project at home for my wife and I did. And so it was going to take, I don't remember, sort of 6-7 weeks. So a guy shows up on day one and he gets one of these big cargo trailers, like the really big ones, right? And he pulls in with his big truck and he backs in this trailer on our driveway. And I remember coming out to meet him and go, our renovation project is not that big. Is it? Like, what are you planning, a demolition? Or do you really need all that stuff? And in the end, the shortened version of the conversation is, well, as I start doing renovations and pulling off drywall and moving things, I don't know what I'm going to be faced with. And so I would rather, like, you probably have every conceivable tool for every possible situation that could come up from a construction perspective. And what was interesting is at the end of the day, I go, oh, okay, that makes sense. I'm thinking of it, why don't you come as a minimalist, right? Mm-hmm. But actually, if you're looking at it for what is necessary for him to do the best possible job, one could argue he needs a cargo trailer full of tools. And if there's a specialty type of cut he needs to do, or do something on a pipe or splice something, there's probably a tool that does it really well exactly for that particular situation. So I've used that in an analogy to say, my estate's not going to be that complicated. Why do I need all these tools? We tend to include all the different administrative provisions, those powers that we're going to go through some examples in a moment. Think of it as tools in that cargo trailer. Right. And it gave me some comfort to know, I hope he doesn't have to use it, but I know that if he runs across a situation, he's got the exact tool to fix that problem the best way possible versus MacGyvering it in some way or hacking it in a less elegant manner. Because I'm thinking, no, I want a good job. This is my house. I don't want a slipshod job. I want the right tools. I want looking at it from an estate perspective. One of the things you want is sufficient administrative provisions, these powers, these authorities to be explicit and give basically the tools to the executor, because as you point out, it can make things go smoother and potentially save costs or avoid any contention about, are you allowed to do that or are you not? So we wanted to go through a few examples of that and talk a little bit about the different powers. And I think the first one, maybe to review, Jenna, was the power to borrow. I know that's a clause that I put in my wills Lots of people have questions about that, but why don't you kick off with that one?
Absolutely. I think that is a very useful clause because if you can imagine an estate that perhaps is heavy on assets, but not really heavy on cash or liquid assets, there's a little bit of a disconnect between the cash available and paying large expenses. So as we've talked in previous episodes, there's certain steps of the administration that there could be a big tax bill owing. One of that could be the final tax return of the deceased. And so let's say $100,000 was owing by April 30th, but the estate maybe only has the primary residence as an asset of the estate and not very much cash. So what does the executor do? Do they delay the payment to CRA and accrue interest and penalties? Or do they borrow some money to try to pay CRA and perhaps save on interest? And that's really a good example of the power to borrow, just giving the executor the power to borrow against assets of the estate to be able to cover some of the expenses that may be owing in the estate administration period.
Great example. And I know that I actually had that in one estate a number of years ago where the fellow died, I think, owning about 7 condos, died unexpectedly. So he was in the phase of life where you buy these investment the condos and then hope they go up in value and sell them. And he bought and sold condos. And that's what he did, right, with his investments. So if anytime he accumulated any sort of cash, he went out and bought another condo and then it was all mortgaged. That was exactly the situation you described, which you could summarize as asset rich, cash poor. And of course, you can imagine if you have these 7 condos and they've all gone up in value, those are all capital gains. This was other than his home. So there was like a significant tax bill, lots of equity in the condos. But what we were able to do is to put a line of credit on a few of the condos to be able to come with the amount of money that was required to pay the receiver general, because the penalties and interest would have been significant. And in that case, the market was a little low for condos, like it was in a perceived low point in the market. So the alternative would have been a fire sale, effectively. Right, is getting rid of the condos at a reduced price. So the strategy was, let's borrow. We'd rather pay a little bit of interest on the line of credit, and then we can slowly sell the condos as the market improves. And it's not a fire sale situation, which would have cost a lot more than the little bit of interest that they paid. And they kept CRA happy. So there was a practical example where some would say, why do you need all that, the extra words in the will? Well, it helped in that situation. And actually, the mortgage company, the bank that was providing the mortgage, I had a conversation with the person and they say, you do have the authority, like the power to borrow clause. And I said, yes, I do. There it is, this paragraph number. And she goes, that's great. They were looking for it. So sometimes people perceive this means the executor is going to go borrow money for their own benefit. And if somebody goes, I never borrow money, like I pay all my debts, why would I want my executor to borrow money? Let's be clear, it's only if it's a net benefit to the estate. Like it would be improper to borrow and pay money on interest when it's serving no purpose. But usually the purpose that it serves is to solve a cash flow problem.
And what would be the second tool that you see quite often, Gord?
I like to see, and I'm looking for the power to realize assets, right? It almost seems trite, but I think it's important when dealing with third parties to say, I have that authority. Right. And now, if you're in that role as the personal representative of the estate, there is some protection or some basic statutory provisions under the Estate Administration Act. But oftentimes you can come in and say, I have discretion about how to realize assets. And oftentimes we're including provisions to say there's discretion to say you could delay it. You could continue to hold it if you determine that to be in the best interests of the estate. So you want to make sure there's that absolute discretion to make those judgments and not saying I got to go in and liquidate everything immediately, because you want to come up with a plan to maximize the value. It involves judging what the market is doing. It involves maybe there's rental agreements. We want to wait until the rental agreement is expired and then we have vacant possession and then we're going to sell, rather than get into a fight with the tenant, or that the timing of the assets with regard to which fiscal period does it land in the course of the estate. Those are all strategic decisions that can be made, and having the explicit authority with the appropriate discretion was very helpful, particularly if there's a challenge by the beneficiaries going, why are you taking so long? Or why are you doing this? Because they can, and they can point to the section right in the will that says, that's my discretion. It was granted to me. I think helps in communication with beneficiaries as well.
I think along the same lines is the power to distribute assets in kind rather than distributing only cash to beneficiaries. And I think this is a really useful tool because, as you could imagine, maybe some beneficiaries want cash from the estate and others want maybe mom's wedding ring or the primary house or a vehicle. And how do you keep those two equal? And so You can certainly distribute assets in kind to a beneficiary who wants that and cash to the other, while the monetary value of both classes are kept the same. And that does allow for people to choose what they want, and it allows for beneficiaries to be a little bit more happier in the end, I found in my past experience. And I really like that clause, and I think it's a really useful one.
Absolutely, saying, okay, there's an investment portfolio, there's two kids, why have to sell all the shares? They get the cash and they have to go back and rebuy the same stock. If they like the composition of the investment portfolio, why not keep it intact and just split the shares equally between the two children? And that would be an in-kind distribution, right? Versus having to liquidate and maybe incur all sorts of commissions or trigger some unnecessary taxes and things like that. So there's lots of reasons why you may want to do an in-kind distribution. That may be preferable for the beneficiary as well. They want to receive the asset versus the cash, right? Or some combination thereof. That's a good one. I appreciate you highlighting that for our listeners. The other one I would put on the table that I've seen is helpful is the power of appointment. I think it's mostly from an estate administration perspective, mostly thought of in the context of delegating or being able to hire people to help carry out your work. And so that you could argue is a form of an appointment. You could say, I'm getting you to do this type of work to help me in the administration of the estate, but it also can be in the context of who might replace you, right? So it'd be important in the will to maybe have that flexibility that the person's, okay, you're the executor, particularly, or you may be the trustee under a longer term trust. And if you get to a point where you can't do it any longer, you have the authority to be able to make an appointment to name somebody else. And then there could be terms and conditions around it. You put in a power of appointment to be able to say, if the person can no longer do it, then in that circumstance, they can go hire a trust company, or they can hire anybody but a trust company. Sometimes the wills are drafted differently, but it gives that authority, which can be very useful. Otherwise, you may be into a more contentious or complicated court application to get somebody appointed when they're not named in the will and there is no power of appointment. So it can be a tool that is quite useful. And from the perspective of the executor or the trustee under any trust, would give some options about who they can bring in to replace them if they get to a point where they can't do it any longer.
And I think another one that is a really powerful tool is related to small trusts. So often individuals may leave a sum of money or an asset to a beneficiary in trust to be managed over a certain time horizon. But as assets change or the beneficiary's needs change, maybe that trust is a lot smaller than the deceased had intended. And so there comes a point where it just doesn't make sense to hold assets in trust anymore, mostly for cost purposes. As we've mentioned, there's an annual tax return that needs to be filed, trustee fees as applicable, other reporting costs. And so it may not make sense to hold a small sum of money for a long period of time. And so having the power to distribute and terminate and end that trust perhaps earlier than originally intended is really good, because it could benefit the beneficiary in the long term. Maybe they will get more in the end by being able to terminate that small trust a little bit earlier than intended.
Yeah, because I've seen that. And in fact, I think a lot of trust companies insist on that type of provision, or that's part of their standard clauses. Because the cost benefit at some point doesn't make sense, right? That the minimum fees or the percent that they're going to charge on a small amount, it'd be just much more efficient to be able to wind it up and get that into the hands of the beneficiary, right? Because the major protection has been there over the bulk of the term of the trust. But if it gets too small, then there's really no benefit to the beneficiary. So having that provision in place is going to give some options to be able to say, I have the authority, because otherwise the question is, you're cutting your job short. Can you even do that? And leaving aside whether a court application may be recommended in the circumstances, it gives some comfort to the person to go, I can do that. And I specifically have that authority. So that's a pretty standard clause, but one you'd want to see in a well-drafted will for sure. The other one I would put on the table as we wrap up here that I've seen over the last couple of years is digital assets. Now that's maybe a podcast article in and of it, or topic in and of itself, to get into what about your loyalty programs? What about digital assets, cryptocurrency, and all the rest of it? But recognize that a good part of our lives is digital in nature, that we have property that isn't physical, it's digital. And that has to be managed by the executor. It's a growing concern as we progress more and more in the digital world. It's an increasing responsibility for executors, one that didn't exist a few decades ago, but it's there now. It's the reality in today's modern society that these are things that people own and they have to be dealt with. So I know we include a digital asset clause. So if you're negotiating with with the holder of that digital asset or a tech company, it may not be a panacea, it may not solve all problems, but I'd rather have it than not have it. And it may give some benefit to the executor to help negotiate and deal with some of that and provide that to the person holding it, going, oh, I'm allowed to manage these. And look at this, years ago, we didn't have these concerns, but they're in there now. And I know it's a standard part of our will. And I think for most lawyers, part of our continuing education and best practices is you should include these types of clauses. So I think that would be a worthy spot of taking up a number of lines on a page of a will to detail what the authority is and give that discretion to the executor to be able to deal with those types of assets as well.
And I'd be interested to see what estates look like in 20, 30 years from now. Because as you mentioned, 10 years ago, there wasn't a lot of digital assets. And as our lives become increasingly online, I wonder if there'll ever be physical assets in the same context that we have to deal with today. So we'll do a podcast episode in 30 years on this, Gord.
Or it'll be our children who pick up this as a legacy project, who are the co-hosts of the podcast, and they can reference in the show notes this episode. I think certainly the point of that is that these things evolve, right? As the nature of the assets evolve, you'd want to make sure that your will is drafted in a way that it gives all the necessary tools, using that analogy we started with, the necessary tools to the executor. And yeah, as you say, 20 to 30 years from now, there's likely a tool in the toolbox that we haven't contemplated today because the laws are different, assets are different, and we now have that specialty tool that's needed to perform that very specific task. So it's one that this area needs to be updated, but they all serve very important roles. And I think for the executor who has a well-crafted, fulsome will with all the appropriate provisions in there is better served, is better equipped to do their job than if they don't have those in place, right? So you'd want to make sure you have the authority, and where you lack the authority or there's some doubt about how to interpret the provision, then a court application may be required. So again, it can be a cost savings measure to ensure that those provisions that are in there, even though they're annoying to read and a bit dry, they're in there for good reason, and they can serve the executors very well and allow them to do their jobs. Good discussion. Thanks to our audience for listening to our conversation as recorded here on these different administrative provisions and powers that executors need and should have. We encourage you to subscribe so you don't miss any episodes that come out. You can certainly see us on YouTube, listen to us on your favorite podcast app. And so we appreciate your subscription. That gets our message out to more people. And if you're able to take a minute after listening to this, if you found this to be useful, please subscribe or forward the episode or mention it to other people. We appreciate the support on that. So until next time, Jenna, stay safe and enjoy the warmer weather we're getting here in Calgary as the seasons are starting to change. And we look forward to podcasting next time.
Thank you.